the arrest of 185,000 naira instrumented through the second defendant has caused hardship and pains to the claimant, who has been unable to live up his responsibility, and the sum of 10 million naira as general damages against the defendants. Then interest rate at 25% per annum of the total judgment sum till judgment is delivered, and thereafter at the same rate till the whole judgment debt is fully liquidated. The claimant predicated his claims on the statement of facts and witness statement on oath filed on the 9th day of May 2019, and the reply filed on the 11th day of June 2019. The defendants, upon being served with the complaint, filed a joint statement of defense and a witness deposition on oath on the 24th day of June 2019. Can you hear me?
You can hear you now, sir.
Yes. Counsel for the defendant nominated 3 issues for the determination of this suit. To wit, 1, whether by the acceptance not of the offer of appointment executed by the claimant, he had not subscribed to be bound by the defendant's current and future policies or guidelines, including the no pay during the massive flood. And secondly, whether the massive flood which occasioned the non-workability of the equipment and non-production did not prostrate the contract of employment and mutual obligations between the claimant and the defendants. And on certification in compliance with Section 84 of the Evidence Act 2011 of Exhibit DW003. I carefully had a painstaking reading of the pleadings and the evidence before this court vis-a-vis issues nominated by counsel for the defendants. The 3 issues subsume the contestation of parties. Thus, I will consolidate the 3 issues nominated by the defendants to determine the suit. On the issue 1, defendants submitted that the claimant executed the acceptance note of the offer of appointment, that is Exhibit CW001, in acceptance of the current and future policies or guidelines of the first defendant, including the policy of no pay during the material times of the massive flood and its effects spanning through September 2018 to April 2019. The claimant signed to be bound by the current and future policies and guidelines of the first defendant and no pay policy as contained in Exhibit CW002 was one of such policies. Hence, the claimant cannot approbate and reprobate at the same time. Counsel cited the case of Angels Spinning and Dyeing Limited against Aja, and also the case of Western Nigerian Development Corporation against Abimbola, and argued that a party to a contract is bound by it. The claimant executed Exhibit CW001 acceptance note and is privy and bound by the no pay policy during the duration and effects of flood, which sprang from September 2018 to April 2019. On issue 2, the defendants were in the business of production bottled water through machines and men prior to September 2018 to April 2019. Massive flood which submerged the production site and equipment, leading to non-workability of the machines and non-production, which occasioned no income for payment of salaries, thus prostrating the discharge of salaries obligation to the claimant, which has been constant. That a contract of employment can be frustrated, and in the instant case, it was frustrated by massive flood, leading to pack-up of machines and lack of income, cited the case of Onigbo against Azubike. The question of non-payment of salaries or breach of contract of employment cannot arise over the occurrence of a frustrating event or circumstances. On issue 3, the defendant argued that the certificate of compliance to Section 84 of the Evidence Act 2011, that is to Exhibit DW003, is in the court case file, duly front-loaded, served and regularized, attached to motion on notice dated and filed on the 5th day of August 2019. And that with 5 Rule 6 of 123 of the rules of this honorable court is instructive as Thus, this honorable court is enjoined to, in the interest of justice, fair play, and equity, depart from the Extant Evidence Act as provided in Section 12 sub 2B of the National Industrial Court Act 2006. I have carefully gone through the processes filed by both parties. First thing first, the claimant filed an application seeking for the extension of time within which to file the claimant's final written address and deeming order. The court granted the application on the 28th day of May 2014. The final written address the claimant wanted the court to deem as properly filed and served was not filed at all. The said final written address was attached to the application as Exhibit A. Despite the granting of waiver or extension of time for the claimant to file the final written address, the claimant did not find it expedient to file his final written address. I do not think the court can deem a process not filed as properly filed and served. Courts of law do not deem exhibits as properly filed, except where they were initially validly filed, but exhibited only to show the court that such exhibits were separately filed. See the case of Idris against Audu. Even if the court granted a waiver to the claimant to pay the default fee, not to pay the default fee, that will not exonerate the claimant from filing the final written address. Exhibit A is not filed and cannot be regarded as a process that can be deemed to have been filed. Thus, the claimant did not file the claimant's final written address in this suit, and I so hold. On issue 3 raised by the defendants, Exhibit DW003 was admitted in evidence. Exhibit DW003 is a computer-generated evidence in which the defendants ought to tender same with the certificate of compliance as required under the provisions of Section 84 of the Evidence Act. Notwithstanding that, the defendants did not comply with Section 84 of the Evidence Act, but the court still admitted same, subject to the privative value to be attached to Exhibit DW003. The defendants argued that the certificate of compliance under Section 84 of the Evidence Act 2011 to Exhibit DW003 is in court case file, duly front-loaded, served, and regularized and attached to the motion on notice dated and filed the 5th day of August 2019. However, the said certificate of compliance was not tendered alongside Exhibit DW003. The law is that courts do not rely on documents not tendered and admitted in the course of proceedings. A fact that does not form part of the legal evidence before a court cannot be used or relied upon by a court of law to hold that it contradicts existing legal evidence. Only documents tendered as exhibits are evidence before the court, and the court cannot act on or utilize any document or fact that is not evidence before it in the determination of any disputed facts or matter before it. See the case of K. Kong against the state. It is important to note that Section 12 sub 2 of the National Industrial Court Act provides that the National Industrial Court to be bound by Evidence Act, but may depart from it in the interest of justice. Thus, the provision of Section 12 sub 2 of the National Industrial Court Act has been struggling to prevail over the provision of the evidence. The struggle came to glare in the case of Sek against Abilo Ososo unreported. It's a Court of Appeal matter decided, judgment delivered on the 21st day of November 2016, where the National Industrial Court admitted in evidence public documents that were not certified on the ground that Section 12 sub 2 permitted the court to depart from the Evidence Act. The Court of Appeal held that the provisions of Section 12 sub 2 of the National Industrial Court Act 2006 cannot operate to encumber the provision of the Evidence Act 2011. Part of the reasons upon which this court based its decision was that the Evidence Act 2011 was made by the National Assembly subsequent to the National Industrial Court Act 2006. But in the later decision of the Court of Appeal, in the case of Mr. Victor Adegboyu against United Bank for Africa, on reported appeal number CA/IL/20/2021, the judgment of which was delivered on the 14th day of April 2022, where the court reversed itself and noted that in sake against Abilo Ugososo Supra, the attention of the Court of Appeal was not drawn to some certain facts. Feel that Section 12 sub 2 of the National Industrial Act ought to apply to this case as it is hereby applied. The lower court ought to have departed from the provision of Section 84 of the Evidence Act 2011, which is hereby departed. Consequently, the order of the lower court discountenancing and expunging the said exhibit VG14 set aside. In view of the foregoing, as earlier held at the plenary trial, exhibit DW003 is admissible in evidence, but other material evidence before this court will determine the probative value of exhibit DW003, and I so hold. On the substantive suit, gleaning from the pleadings before this court, it is not in dispute. It is not in dispute that the defendants employed the claimant where the offer of appointment dated the 3rd day of November 2015. That is exhibit CW001 or DW001. It is not also in dispute that the claimant resigned his appointment with the defendant via the exhibit CW004. It is also noted that the defendant did not pay the claimant the salaries for November 2018, December 2018, January 2019, February 2019, and March 2019. And it is also not in dispute that there was a massive flood which took over the workplace of the first defendant between October 2018 to April 2019. It is tried that where both parties to a dispute have agreed about a particular matter in their pleadings, such a matter need not to be proved, and the court should accept such an agreed fact as established without proof. See the case of AGIB State against AG Federation Company Limited against Arctec International Limited, where the Court of Appeal held that Section 4 and 5 of the Evidence Act defines a fact and issue as including those facts necessary in order to prove or disprove, to establish or refute a case. They are facts necessary by law for a plaintiff in a civil action to establish his claim, and those the defendant must prove to make out his defense. They are those which by pleadings are said to be in dispute. In short, those upon which the parties seem to have joined issues, unquote. The anatomy of the claim of the claimant will impeccably reveal that this suit was brought for the payment of salaries from November 2018 to March 2019. The claimant pleaded in paragraph 12 of the statement of fact that the defendant owes him 48,500 for November 2018, 48,500 December 2018, 20,000 for January 2019, 20,000 January 20, February 2019, and 48,500 for March 2019, totaling 185,000. The defendant in their defense stated that the 2018-2019 massive flood, which resulted to the submerging and pack up of the first defendant production machines or equipment, leading to non-production, shutdown, and lack of sale was a force majeure, an act of God which naturally, equitably, and legally involves prostration of contract, a state of affairs such that the defendant's obligations from October 2018 to April 2019 are deemed overtaken and obliterated. That the first defendant only received a letter from the claimant and the same was replied accordingly, as the reply was not on the instrumentality of the second defendant. Acts of God like flood occasioning non-frustrate equipment workability and contract obligations, as the defendants are not liable and they are not wicked. The defendant argued that the claimant executed the acceptance note of the offer of appointment, which is exhibit CW001, in acceptance of the current and future policy or guidelines guidelines of the first defendant, including the policy of April 2019. The claimant signed to be bound by the current and future policies and guidelines of the first defendant. And the no-pay policy as contained in Exhibit CW002 was one of such policies. Hence, the claimant cannot appropriate and reprobate. Counsel cited the case of Angel Spinning and Dyeing Limited against Aja, and also the case of Western Nigeria Development Corporation against Abinuta. Clarity. The acceptance note in Exhibit CW001 read as follows, and I quote, acceptance note. I, Akbox Ejeta, do understand and accept the terms and conditions of this offer of employment to me. I will be fully guided by them. I also understand that this is not a unionized employment, and nothing of such shall be practiced by me or with any group of people while I remain in the employment of the company, effective from my assumption of duties. I accept to be dismissed from the company without any benefits whatsoever if I am found to contravene the company's non-unionized policy or any of the company's values or code of conduct that guides my employment in the company as enumerated above, and such other policy or guidelines that will still come into effect thereafter at Lamo Foods Industries Limited. Unquote. The underlying fact of Exhibit CW001, which I did, is devoid of ambiguity. The law is that while a document is clear and unambiguous, the operative words in it should be given their ordinary and grammatical meaning. Thus, where the language, terms, and intent or words of any part or section of a written document, written contract or document or enactment are unambiguous, they must be given their ordinary meaning. As such terms or phrases used best declare and present the intention of parties, unless it will lead to absurdity. Unless it will lead to absurdity. Or be in conflict with other provisions thereof. See the case of Williams against Williams. In the instant case, the claimant has agreed to be bound by the first defendant's code of conduct as contained in Exhibit CW001 and any other policy or guidelines of the first defendant that will still come into effect thereafter. The defendants relied heavily on Exhibit CW0 or Exhibit DW002 to argue that the claimant having been bound by any other policy or guidelines of the first defendant that will still come into effect thereafter is not entitled to be paid its arrears of salaries for November 2018, December 2018, January 2019, February 2019, and March 2019. Inasmuch the defendants under paragraph 7 of Exhibit CW002 or DW002 have decided that no salary payment shall be payable to staff at any of such forced work stoppage, force majeure, and staff will be required to stay safe at their homes. However, a careful perusal of Exhibit CW002 will, without share of doubt, delineate that the effective date of the operation of Exhibit CW002 is the 1st of April 2019, whereas the arrears of salaries the claimant is praying or claiming for are for November 2018 to March 2019. The implication here is that the defendants cannot deny the claimant his entitlement for the arrears of salary for November 2018 to March 2019 because Exhibit CW002 had not been born or operational between November 2019 to March 2019. November 2018 to March 2019. The law is that specific date of commencement in a document can be made with retrospective effect. It may commence immediately after or on the date of signing it, or it may even be in the future. In other words, the date which usually gave birth to a document can operate in the past, present, or future. See the case of Oruku against Oruku, reported in 2024, 1 NWLR Part 1919 at page 371. The Supreme Court, in the case of APC against INEC, held that, and I quote, thirdly, I think it stands to reason that where a document has been signed and in it is provided a specific date of commencement or date when effect is to be given or action to be taken, That date must be taken to be the effective or commencement date, irrespective of the date when the officer signing the document on behalf of the authority appended his signature. That specific date of commencement can be with retrospective effect. It may commence immediately after or on the date of signing, or it may even be in the future. In public and civil services, and of course with private corporations, appointment or promotions or demotions may be done with retrospective effect or immediately. If it is a retrospective, the officers concerned take arrears of their entitlements attached to that office. On the other hand, if the document is silent on the commencement date, then it will be presumed that effect is to be given to it from the date the officer signed the document. Unquote. From the pleadings filed and the exhibit tendered, exhibit CW002 came into force on the first day of April 2019, and the claim of the claimant before this court is a period between is for the period when exhibit CW002 was not yet operational. That is between November 2018 to March 2019. For this reason, the claimant has successfully proved his substantive claim against the defendants. On the issue of general damages, the main claim of the claimant is in the sum of 185,000 naira. The amount is so small compared to the expenses the parties might have incurred in the course of prosecuting this suit. Again, it is not every time that the parties should be held bent on litigation. I suppose if the defendants properly consider the pleadings and the documentary evidence before this court, the parties will have resolved this matter without a full-blown trial. Courts are at discretion in the award of damages. The failure of the defendants to pay the claimant is entitled, according to the claimant, subjected the claimant to hardship and pain. Such award will depend on assessment based on certain considerations. See the case of Shell Petroleum Development Company Limited against John, citation provided. In all, I hold that the claimant has proved his case and he is entitled to judgment. It is hereby ordered as follows. A declaration, I declare that the first defendant is indebted to the claimant to the tune of 185,000 naira only as salary arrears between the month of November 2018 to March 2019. I declare that the continuous refusal of the defendants to pay the claimant's salary arrears of 185,000 naira instrumented through the second defendant has caused hardship and pains to the claimant, who has been unable to live up his responsibility for his family, and I award the sum of 200,000 naira only as general damages. I decline to grant relief sought by the claimant for lack of proof, and all terms of this judgment are to be complied with within 13 days from today, without prejudice to the right of the parties to appeal against the decision of this court. Judgment is hereby entered accordingly.
As the court pleases, we are most grateful, my lord, for the well-considered judgments. We are most grateful. Thank you, my lord.
Yes, the second parties, are they around? The second matter? Nobody. They didn't get it. They are not here.
It's not about
So when he join, let me know. When he join, let me know.
I called them when I went out. I had to copy the phone. Where to receive me. Like 2 weeks ago. Anyway, we're not sure if I will forward it to them now. And they want to. Way, but she told me you send it to the nature, please, you should do that. And that's when I was, and I saw that they were here to join. I just tried designing to call vendor to the house where the city. Just for him to see my call and then check his message. I'm already on a city. She may be where your government lawyer, a worker, you're flashing. Actually, it's not about flash. I was trying to confirm if you got my message. There, I got it. If someone is trying to. You can't even acknowledge. Imagine. Hello, sir. You're welcome. Hello, sir. Can you hear me? Hello, sir. Can you hear me?
Yes, I can hear you.
Good morning. You're welcome.
I can hear you.
Yes, my lord had to stand down the matter. We are waiting for the other part, the other counsel to join. Sorry, please. You are for who? The
Okay.
defense? No.
Okay. I am for the defendant.
Okay. No, just hold on.